being with us here at the collective. We've got a good group here, and we're going to get into some creative finance stuff. I know we were just coming off a conversation here in the background before we went live, but as we were discussing some of the things to talk about creative finance wise, one of the things that came up, Sean, you and I were talking about this the other day, and I feel like we've addressed it a number of times, but it just keeps coming up. So I wanted to get everybody's thoughts about this from everybody's different areas. So, we come from uh, a number of different states, but like I said, this just keeps coming up, and that's deeds in lieu of foreclosure in advance of a foreclosure. I see in Facebook groups this question keeps coming up. Hey, I saw this form or I saw this idea where why can't we just get a deed in lieu of foreclosure on our creative finance deal right at closing, right at the beginning of this thing, so we don't even have to deal with the formal foreclosure process. We've talked with a number of you on the show about all the problems with this, but why isn't this just, I'll just pose this to everybody. Why isn't this just skating around the formal foreclosure requirements set forth in each and every state?
I can throw my 2 cents in real quick because it's kind of easy and quick. I tell my clients that it's an executory agreement that, if challenged, will not be enforceable, but it's very unlikely to be challenged in the situations that we deal in. But that's my understanding. So I think there's already value in this program because I'm interested to see what y'all think.
Also, I'm pretty quick on it. I despise what I call pocket deeds. If you've got a deed, it needs to go of record. Yeah, go ahead.
Go ahead, Drew. Sean had jumped
Yeah,
in there, but Drew, go ahead and finish your thought.
No worries. I just despise pocket deeds. I don't like deeds that are executed or not recorded of record. It just causes all sorts of hassles. Another thing, at least in my jurisdictions, are a deed in lieu doesn't actually help you clear your title. So coming from more of a title background, part of the foreclosure is it wipes all junior claimants, basically, right? And deeds in lieu don't do that. You're just taking it subject to whatever the title is there, at least where I'm licensed.
So hopefully you guys can hear me. If somebody can hear me, nod their head.
To his point.
Yeah, Go ahead, Jeff. We can hear you.
Yeah, we can hear you, Jeff.
He must not be able to hear us. Sean, go ahead and give us where you were going.
Yeah, I mean, Alan's point where he indicated, well, whether or not it's going to be challenged and who's responsible for challenging it. It's being used in two circumstances. One is the acquisition side of things, where, you go to the seller and you say, okay, well, I'll give you a deed in lieu of foreclosure. And, in that case, you're the investor, you're giving the deed foreclosure. You're probably not going to challenge it. If you don't pay, you expect that the seller is going to record the deed in lieu. Problem, to Drew's point, what the seller doesn't appreciate or understand, I'm not sure that the disclosures are being made so that they're aware of it, is if you go and subsequently record that deed in lieu of foreclosure and the investor has further encumbered the property, the investor has, has an IRS lien, has some issue out there that has a judgment that's been recorded, and it's attached to that property subsequent to the, original acquisition. Well, in that, the unsuspecting consumer seller is going to renew, and all of a sudden it's like, oh, hey, now your property's encumbered, by a $200,000 IRS lien or just like that. When had you just gone through the normal process, you would have wiped it out and you wouldn't have that issue. I think, to me, that's the biggest concern with doing this side. On the disposition side, I would never do it. you're basically asking a consumer a deed in advance and do an in-run around the foreclosure, practices and in that case, that consumer definitely objection. And in my view, at least here in Arizona, they would win that, and prevail on that claim. And, the investor could end up in a lawsuit in hot water over taking it on a disposition.
Yeah, I think we're kind of all in the echo chamber right now, because I agree with what all of you have said. I think that they can sometimes seem to be a quick solution to a small problem, but then, as you guys have all mentioned, it's not without its own numerous problems. And yeah, the main thing that I was going to mention is that unlike a foreclosure, it doesn't clean up the title. And so you still have all those extra issues dealing with whatever interests or encumbrances or other things like that that are on the title that make it problematic, in my opinion.
So what do we tell all of these, the people who are bringing them from the gurus?
I mean,
the gurus aren't accurate. I mean, I have no qualms saying.
Yeah, took the words out of my mouth. I was going to say they're gurus, and I'll put that in big quotation marks. And so if they're coming to their attorney, I'll explain all of this to them, and they can proceed how they want to. But I say, look, are you hiring the guru and paying them? Well, they probably are paying the guru hundreds of dollars an hour, but nonetheless, you're not going to be going to the guru when you have legal issues. So yeah, I just tell them, you can decide who you want to take your advice from. I'm giving you what my advice is.
Hey guys, it looks like we have Scott Horne with us now. Scott, can you hear us?
Yeah, I'm on the phone and not the computer, but you know what? It works, right?
Yeah, no, you're coming in strong. So you're just joining in kind of a conversation where we're discussing this question keeps coming up, and we feel like we've answered it thoroughly over the weeks and months and years, but everybody keeps wanting to put together a pocket deed in lieu of foreclosure right at the commencement of a creative finance transaction, so they don't have to later foreclose. And we're talking about the problems with that. What are your thoughts?
Do you want the no answer or the hell no answer? Because it's really both. This is something that we addressed this issue back in 1990. And I reached out to some of the biggest banking firms here in the Dallas-Fort Worth marketplace just to canvass them on ideas like that. This is nothing new, but of course, everybody thinks it's new, so all of a sudden it becomes the fad thing to want to do. And without fail, every one of the law firms went, yeah, no. By the time you give enough notices to do something like that, you could already foreclose, at least here in Texas. So maybe in other states, if you set up certain prerequisites, you might be able to do it. But here in Texas, there's a statute surrounding that where the borrower can nullify it if they wish to do so. And so I am just not a fan of a unrecorded deed. I can't even imagine what it looked like to a title company if you have a mortgage dated, let's say, July the 1st, and now you've got a deed in lieu of foreclosure dated July the 1st recorded. I think it's so problematic. I suggest everybody I deal with to stay the heck away from it.
Yeah. I think that is the consensus. So now when we get questions that come up about this on social media, we can just clip out this last 5 minutes and say, all right, have enough people agreed for you all just to go along with this at this point and not do it any further. For folks that are just joining us, this is the Creative Finance Collective, and this is an opportunity for lawyers and professionals in the space of creative finance to get together and talk through creative finance issues and questions and discuss, what they're seeing in the space, so on and so forth. You'll note that at the bottom of the screen, we have everybody's contact information and everybody's, their websites and their names. But for the folks here that are present, we've got myself, Sean St. Clair is here, Nick McGrew out of California, Alan Seschker and Scott Horne out of Texas, and Jeff Watson from Ohio, but not coming to us from Ohio. More like, what'd you say it was, Pennsylvania, Jeff? So if you're just joining us, we're talking about taking pocket deeds in lieu of foreclosure in order to, in an obvious attempt to avoid the foreclosure requirements in any given state. I think the consensus is don't do it, and don't do it. That's it. So another question. We talk a
But
lot
Andy,
about,
let me make a comment. We can sit here and talk about that until we're blue in the face, right?
yeah,
And guess what they're going to do?
they're still going to do it.
Ask for it, but it doesn't mean we're going to do it.
It's just the way it's always been. Doesn't seem to change.
If we have a closing and they're wanting to do that deed in lieu, pre-deed in
There
lieu,
is the positive and yeah.
we tell them, y'all can go and get that signed off and notarized separate and apart from our closing, but it's not a part of our closing.
Yeah. And I'm going to just make a comment to the gurus that teach this. Y'all don't own title companies. Y'all don't know how to clean this stuff up, the messes that you teach. And once you figure out the mess that some of this advice causes, you'll stop doing it.
Good advice.
Yeah. Yeah. So a follow-up, another creative finance question. We talk a lot about creative finance with respect to residential property. Are you guys seeing any creative financing happening with commercial properties?
Absolutely.
Yes.
We don't do a huge amount, at least in our offices, but we do one a month of various sizes.
Yeah. The last 3 commercial deals that I've been involved in, either representing the buyer, representing the seller, or being a co-GP on the buying side, they're all creative terms in there where everything is, and what we can call it creative, we can call it private financing, we can call it non-institutional, but we're doing deals without banks coming and controlling the situation. We're doing it without bank money.
For
I think it works just as well in commercial as residential. Here in our Texas marketplace, we still have some, whether it's residential or commercial, there's still some disclosures that need to be put into the contracts and the closings and whatnot. They make it a little bit harder for guys like Alan and I to do business here in Texas than you guys out in Arizona or California. I don't know about California. I don't want to practice California. But, at least they have some things in our property code and finance code that I think it relates over to the commercial world as well as residential. But yes, and I don't think the commercial lenders care as much as the residential lenders do, it seems like.
I agree.
Nick, you're up in California. What have you seen?
Yeah, I was going to say, so for the relatively smaller deals that are owned by kind of a more mom and pop shop or less of a machine, so to speak, I see a good amount there. But at the larger deals where we've got, not necessarily institutions, but we got investors and things like that, there I see more traditional. But if it's, if we have a single owner or a handful of ownership in the group, then we do see some creative situations occasionally.
What do you guys think? Do you think that the typical promissory note in a commercial transaction, being that it's not going to be your traditional 30-year fix like in a residential deal, do you think that limits overall the number of creative finance deals that can happen in the commercial space?
I don't think so.
How are we defining creative is my question on that, because a lot of things, obviously commercial has a lot more of a free hand to do what you want because you're not looking at TRID, right? So how exactly are we trying to define creative on this? Because there can be very creative clauses, right, inside of your promissory notes or your loan agreements that you could never find in a typical 3-page residential promissory note.
I think he means taking the property subject to doing a wraparound financing is what I think is what he's relating to, other than just clauses within the scope of a standard document.
That's what I mean.
The ones that I see,
I can read your mind.
the ones that I see are bank is involved. Bank is giving approval for the sub 2 acquisition, not necessarily qualifying the buyer as much. We do see that happen though, but they're in some form or fashion, they're involved in signing off on it.
I'm nodding my head yes, because that's exactly what we've seen in the last 3 deals is we get the bank to see what we're doing and bless it as we're swapping in and out people and leaving the institutional debt in place and not bringing in nearly as much as we'd have to and keeping the low interest rates and secure it in there. So we just draft around what the bank requires, negotiate with the bank, and go from there.
But, you know, I think if you've got a small commercial bank involved, I think it's easy to reach out and discuss with them. I think bankers understand this stuff for the most part. But it's if your underlying debt is, let's say, an FHA type loan of some type out there, commercial, you're not going to be able to reach out to them and get their permission to do it.
So another question. Are there times when you want a due on sale clause, or when, I guess I should say, when do you want a kind of a transactional question here, a due on sale clause in the wrap note and deed of trust?
I'll jump in. As an investor, I want it every time, and I've never denied someone to resell that property. I'm not going to act on the due on sale clause. I want 2 people to be responsible, pay my note, and so I put in all my disposition documents for me and all my people.
Yeah. And I think I agree with, I agree with Alan to that regard as an investor as well, that when I'm selling a property, I want my due on sale clause in there in order to control the transaction. But, you know, again, what we see in our marketplaces, guys, is the traditional seller out there, the mom and pop who are selling their homestead or something of that nature along the way. They don't know to ask for the due on sale clause. They don't know what to ask at all because they never incorporate either a realtor, which is going to be totally blind anyway. Rarely will they ever reach out to counsel to get, you know, an answer or to review documentation. And so they don't even know, so it's never a request. I think the more sophisticated investor, you know, an Alan, myself, whoever else might be in the marketplace out there, I think we're always going to want to put that in there for control purposes, one way or the other. And whether you elect to allow them to sell to a third party or not becomes problematic based on the deal and the situation along the way. But I think what we see so much of is, even in the investor world, the investors themselves are unsophisticated. And so they don't know to put it in there or not put it in there. And so sometimes we got to bring it up. They want it, and then they don't really know what the answer is along the way.
Yeah, as you asked that, I was kind of thinking, I can't think of a scenario if we're going from the perspective of the seller where you wouldn't want that. Because that with having that in, you're going to now have 2 people that you could hold accountable for that. And just because it's in there, you don't have to enforce it, but you at least have another card to play in case there's an issue. So yeah, if anybody has a scenario with a seller, I'd love to hear it, just because I haven't encountered a situation where I wouldn't want that in when I'm working for the seller.
Yeah, this has to step up and question. It depends. Oftentimes, if your buyer is in the investment world, they don't want a due on sale clause in their mortgage between them and the seller, of course. But if the investor is the seller, then of course they do want that clause, you know, in their documentation. And it's just go to my banks here in this marketplace, and they all put due on sale and take it out. Now, do they give me permission to earlier to put? Absolutely. But they leave the clause just in case they need a back perspective in some scenario along the way. I just think it's a little sophisticated out there, and then it's looking what type of a transaction it is, parties to move forward with what they're really looking to accomplish. The bottom line is, I think if you're going to be in this business as an investor, the word control comes into play, because I think we're all control freaks at the end of the day, and that's what we want to be. That's what protects us from these deals. And so many people, they don't know what can happen downstream, which is what's to ask the question.
So I want to back up a little bit and make an observation. I'm working with two different classes of investors, and I work with the people who I refer to are in the buy and breathe generation. They've been investors since 2012 till now. All they've had to do is buy real estate and breathe, and they've made money. It's gone up. And so they're the ones that don't know what they don't know. The other group that I work with, I'll just put them under the umbrella of the old Jack Miller school. I work with a lot of the Millerites, Jack Miller followers, and so on, second, third generation Millerites. They know it, but they're not really comfortable writing it themselves. And so they'll reach out and say, hey, how do I write this? And, then we'll talk through the concepts, and we'll have a much more expansive conversation, because they're much more aware of what they can and can't do. But the buy and breathe crowd, they've been just using the big cash hammer to buy houses. That's all they know. I mean, HGTV has trained them how to, that they can make money just by buying and flipping. So there's a lot they've got to learn still.
Yeah, I completely agree with that. I've been saying, the past 5, 7, 8 years, you don't have to be a good operator, and you're going to look like a rock star just because the market is taking you up regardless. Now we're seeing things change a little bit, so I'll be interested to see what the next 2 or 3 years look like, because now the market's not going to save every deal and make you look like a rock star. And so you're actually going to have to know how to operate that property to get the returns you're expecting. And we'll see how well those guru students are doing or not doing when they have to actually earn it and work for it.
Well, the good news is these sophisticated investors are going to have a field day as they pick up the properties that the amateur operators just are not going to be able to handle. I mean, I don't know if y'all saw it, but we saw quite a bump up in the commercial side, because people that bought when rates were low, they couldn't afford to refi when their 3 and 5 year loans matured, and so they've had to dump it on the local market.
No, I think you're.
So let me
exactly those kind of things happen.
So can I jump in with a follow-up question on the due on sale clause? How does everyone always say 0.000005 of our deals have had a due on sale clause issue? Kind of small, but when it does occur, how do you fix it? How do y'all go about it?
Had that issue, luckily.
We
Knock on
can't
wood,
claim
right?
trade secret. Well,
I do the cat and mouse game. I do the cat and mouse game where we deed it back to the borrower and deed it back to the buyer.
Well,
I do something similar to that. I'll deed it back to the original borrower, and then I'll put a master lease with option in place. And the option strike price is the ever decreasing principal loan amount. And we've still tied the property up. Yeah, we put it back in the name of the original borrower, but we've got control of it because we've got the right to occupy it. We've got the right to sublease it. We've got the right to buy it when we want to. So that's the way I solve that problem. I think I've had to do that once so far, and by looking at my emails, I think I've got another one coming. Somebody didn't listen to what I say about not doing it with FHA, and FHA's caught it and coming after them. And I told it back in December. I said, folks, watch out. If you're going to do this on an FHA, you better be ready for them to rattle your cage, because they know about it and they're not liking it. That's my 2 cents.
Yeah, Texas, we can't do the lease purchase option for all intents and purposes. There are ways to do it, but I'm never helping I'm not helping anyone do a lease purchase option if it's even allowed, just because of the complexity of the statute.
Well, they're going to mess it up. Fowler, is what they usually do is they don't know how to follow the statute sufficiently, and they open themselves up to. But in your camp, not the direct cat and mouse, I kind of incorporate a land trust in the middle. We notify the lender. A lot of paperwork is why I think, in this industry, that's why disclosure, I think is so important, both at time of contract closing, because, due on, we said earlier, it is not very problematic to happen. When it does happen, you got to be able to contend with it. And luckily, you've got plenty to deal with it and work through it in most cases. I kind of interesting. I don't know about it, but I've seen some stuff recently in U.S. bank documents. If y'all have dealt with a U.S. bank loan lately, where it is a tax-free clause in their bank documents. Have y'all seen that at all? Of course, it's not to the borrower who bought the property, and they're sitting people in Texas. Once you buy, you cannot lease anymore. You cannot move out of the house. And of course, statutorily and constitutionally, you can't do that in Texas. But it's amazing that they talk to you as if. So I've just been successful, at least in the 8 or 9 times due on sale and getting around it. Just as Alan said, the cat and mouse game to a certain degree. Great odds. There's not going to be a problem out there, but you got to be prepared for it because it can happen.
Has anybody seen, Alan mentioned this at the beginning of his question, which lenders calling loans due is a very small percentage of the time. Can anybody speak to, or has anybody seen any frequency recently? And I guess recently, maybe in the last 90 days, it would suggest that more lenders are calling things due more often than not. Jeff, you mentioned you've seen it in FHA context, but is anybody seeing that, or is this still kind of a theoretical discussion for everybody for the most part?
The one I've got, I think, is a one-off. I'm not seeing a trend. I've been warned by a practitioner that practices in Virginia, whose next door neighbor is high up in FHA, that FHA is out looking for it. But that's the best I've got. I've only seen one. I've not had a bunch of people coming at me, and I'm like you guys. I teach sub 2 on a regular basis, so I mean, I've got one. That's the best I got. I had one other situation a few years ago. It was quick to solve, and so it's not been a big issue.
Yeah, I think
I always say
you got to realize you're dealing with the federal. I was just going to say real quick, guys. Just realize who we're dealing with. It's they're going to go out and hunt these deals. They talk about it. It's just not going to happen, I don't think.
Yeah, the ones that have happened with us are what I say usually some type of mistake or even silliness with the parties. We had one guy, call it hug your enemy and pull the pin. They wanted something bad to happen. They were mad about the sale. One was a condo regime went out of business. My favorite one was the seller took her mortgage wrap loan documents over to the small bank and said, hey, I sold this property. Now I want to get a different home equity loan on this house. And that caused a problem. So it's usually something to do with the parties or an error in the insurance getting in play, something like that.
Yeah, I knock on wood that fortunately none of the ones I've ever done went sideways, but I have had clients who closed elsewhere that brought me files, where, as you said, someone had pulled the pin, because I had said this last time we were on, is the fact that she sold her deceased mother's house and she was the executor. She also happened to live across the street from it, and she was very unhappy with the changes that the flipper was making to her mother's home. And so she just called the bank and said, I sold it. He just pulled the pen and blew that whole thing up. I don't know if y'all have had issues before, but the larger banks, especially, you're not the borrower, and they'll just point to TRID and say, I can't talk to you. Right. And so I've actually had to counsel clients to go hire, a litigation attorney to go drag the lender to court to try and get a payoff, because they'll just start the foreclosure process and ignore anyone other than the borrower trying to talk to them.
I've seen that.
Yeah, and of course there's statutes both,
If you can't
in
fix,
all
still
states.
holds true.
Go ahead, Sean.
Yeah, so and there's statutes in at least in Arizona. I know even there's federal statutes for federally insured loans that these lenders. That's what I don't understand is these lenders, they know they have to provide payoffs, reinstatement figures to anybody that is a successor to the borrower, even if they take it, subject to existing loans, even if there's a due on sale clause violation, they have to, provide that payoff. In Arizona, it's 14 days. And if they don't, there's statutory damages for that. And, and even if it's MERS and they can't find the servicer, or track down the servicer. I mean, I've gone round and round with MERS and, finally reached their legal department, but man, that's frustrating, Drew, that, you have those situations when the law is very clear that it doesn't matter if you're the original borrower or not. If you're a successor, you have a right to those numbers.
Is that federal or Arizona?
Well, there's federal CFRs for Fannie Mae, Freddie Mac, FHA that state that payoffs have to be provided within a certain amount of time. I don't remember the time under federal law, but in Arizona, we have a statute that says that even a second position lien holder has a right to receive a payoff of the first, even if they're not the borrower. Payoff and reinstatement, amounts. Anybody with an interest in the property has a right to that. And I don't know, in Texas, are you aware of statutes similar to that?
Not Texas. We use a federal statute that we actually put on every one of our payoff requests that states that they're required to provide that under federal law within 7 days, which I'm pretty sure it's 7 days. I might be wrong, but I've never found anything in Texas law that has that requirement.
Yeah, in Arizona. So in Arizona, we have and you probably see this here. And I think Alan, you published something recently on like title issues and resolving title issues. In Arizona, if a lender fails to release a paid off deed of trust within 30 days, they're subject to, liability. And then you can catch them for statutory damages if you send a written notice and say, hey, you didn't release within 30 days. So here's the written notice to release. And you have another 30 days or it's statutory damages, even if I don't have actual damages. But what's interesting and what I like to do is I'll reduce that time to 14 days because I'll say, hey, your deed of trust is still a record. So as a beneficiary under that deed of trust, you have to give me a payoff in 14 days. And for you closing attorneys here, is a $0 payoff good by you? Right? So I've taken now the statute from, the time frame to release the deed of trust that didn't get released because the servicer, whatever, it was in the middle of transfer or whatever. I've taken that and reduced it to 14 days because I'll take a $0 payoff.
So it sounds like you don't have the ghost mortgage issue that we have out here in the Southeast.
Talk to me about that.
So obviously the 2008 financial crisis was a bit of a problem for a lot of lenders because they lost their underlying promissory notes. And so I occasionally on the title side, I'll run across files that have open security deeds, from 2008, 2009. And obviously the bank is no longer in existence. Generally, the bank that bought them is no longer in existence. So, you go following up the chain until you figure out that it was bought by Wachovia. And of course, Wachovia got acquired. But, oh, wait, not that part of the loan portfolio. That part of the loan portfolio went to Wells Fargo on this other entity over here. And so you finally track them down. And then all of a sudden, you're having to make requests to like their archival team. And I mean, sometimes your closings take 2 months because they finally report back and say, yes, we acquired the assets of this bank bank, which acquired the assets of this bank, which, supposedly would have acquired the portfolio, but we have, no record of a loan to so-and-so. And then you're clear to close.
Yeah. So no, we have that problem here. Now, if MERS is the beneficiary and there's been no assignment recorded, I just go straight to MERS and I basically say, hey, look, you're the beneficiary of the deed of trust. It's not my problem that the servicing transferred. It's not my problem that you can't reach the servicer. It's not my problem, any of this. As the benefit, and our statute's very clear, as a beneficiary of the deed of trust, you must provide me with a payoff in 14 days. I don't care that you can't find who services it. I don't care any of that. That's you chose to be MERS. You chose to be that clearinghouse, and that's what you chose to do. You got paid to do that. Take yourself off these deeds of trust then, if you're not going to play ball and comply with our statutes. And so I actually have a couple of numbers to in-house counsel at MERS, and I know this is public record, but it's out there, and I call them, and I have the lien release department at MERS, and we get it done if it's MERS. If it's not MERS, there's a couple of, Arizona has some pretty great statutes to get those ghost deeds of trust or ghost mortgages released. So if I can show that the lender is not located in the county where the property is located here in Arizona, and I can provide clear and convincing proof that the loan has been paid in full, I can go into court ex parte, file an application for order to show cause without notice, and have a judge sign a release of the deed of trust without ever serving my complaint.
Whoa.
Yeah, just like what? Yeah, I've gone in and had those things released in less than a week by a judge's signature. In those cases, the servicer's gone under. We can't find them. They're clearly not here in Maricopa County. I give all that proof, but you have to have clear and convincing proof that it's been paid off. That's the key. If it's kind of like, well, judge, statute of limitations and blah 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 blah. We think, you can't do any of that. It has to be, here's a HUD-1 or a settlement statement. Here's where we got the payoff from the lender, et cetera. And here's, the copy of the check. But yeah, if you can do that ex parte, and we release it here in Arizona. So, and we have statutory damages if they don't play ball and give us that information. So, when it's a corporate servicer or corporate lender, that isn't a problem. Where it gets tricky is on like old seller carrybacks and old agreements for sale that they've been performed, but at that point, you have an individual that you're dealing with and trying to get information from and trying to get them released and tracking down individuals and their heirs and whatever else. But when it's corporate, I honestly don't have any problems getting them released in very short order.
So it seems like the Southeast has kind of approached
I
a little
think
bit
they bring
different
those
because
statutes
you talk
in.
about with the creative financing. Oh, go ahead.
Statutes to Texas.
I can't hear.
Nothing.
He was saying that you need to bring those statutes to Texas. I agree. They need to come to Georgia as well. The title underwriters here try and solve it a little bit differently. So obviously, if you have a big institutional lender, you just close and you can rely on the statutory damages. But as you said, when you have like seller financing or you have like, hard money investor financing, specifically trusts, you will very often see in your Schedule B1 requirements that you have to have a payoff, that you have to have a release in hand before the title company will agree to insure, because institutional, they know the rules, you're going to be able to find them, but instead of having to go track down, a trustee or heirs or something else, it'll actually be one of the underwriting requirements that you have to have that release in hand before, you can actually get clear to close on the title side.
Well, that's same in Arizona. We have to have a release either by a judge's order or by, a signed release.
I don't think we have the judge's order shortcut.
Oh, well, what do you do? What do you do? I mean, you're telling me that now you may not be able to do it ex parte, but you're telling me that you couldn't get file a lawsuit for declaratory relief or declaratory
You probably
judgment?
can. You probably can, but I don't go to court, remember? So at that
Well,
point, I would
yeah,
hand it
but
over
I mean,
to a
having
litigator to say, hey,
litigator,
you know,
have a litigator
yeah.
do it and go to court. And well, you're a closing attorney. I mean, if say Brian, who's licensed in Georgia, Brian Locker from our office, let's say he goes in and files a deck action, serves the complaint, obtains a default judgment stating that, hey, look, Lena's deed of trust has been released. Are you saying that you guys wouldn't close with a signed final order or judgment from a court of
No,
jurisdiction?
we would totally close if we had that.
Oh, okay.
It's just we don't generally have to go that far. And a lot of times, depending on how old it is, like for example, I've got one closing tomorrow back in Alabama. It's a $40,000 from 1990. It's never been released, had no maturity date because back then in Alabama, you didn't have to state maturity dates. But given the circumstances, given that we've had multiple, first position term loans since then, the title company said, get an affidavit and write over it. So, I mean, we do have ways, but if it's one of the seller's loans and the person or entity can be found and it's not an institutional lender, we have to have the release in hand. Obviously, if we're paying off Wells Fargo or, Face Servicing or whatever it is, we don't have to have the release in hand because the institutional guys, they file releases. And if they don't, you send them a strongly worded email, with the statute saying, hey, you're up for, $600 in damages plus attorney's fees, get this released. Thank you.
Yeah. And I will tell you, the title companies aren't as lax, like what you're saying. If you have something inside of 50 years, because that's our statute, deeds of trust are deemed released or void and of no force and effect after 50 years, unless some renewal's been recorded. But anything within that 50 years, even if there's a few owners removed, most title companies are going to make us get that squared away. Now, once again, if you're a few removed, then you have probably a title insurance claim somewhere along that chain, and maybe the prior title company that closed on it will close on the next one.
Yeah.
But they won't generally write over that, at least unless they're the ones that actually closed it originally.
No, so again, this comes up from time to time and we get letters of indemnity or, depending on the nature of it, it'll fall under the MIA, right? The mutual indemnity agreement between the major underwriters.
Right.
And so we are able to move forward. Again, if it's recent, absolutely not. But the age and the status of title, again, multiple term loans and refinances over time seems to give a lot of comfort to the underwriters that, clearly there's, even though it's still there of record, it's not there of fact.
Now, do you guys have in Georgia? We have this in Arizona, and this is really comes into play for private seller carrybacks. I mean, we're talking creative financing, but so private seller carrybacks in Arizona, if you have a private seller carryback and the lender dies, for example, and it's been paid off, it's just they didn't release because it's a private individual who got payment. Do you have in Georgia where you can track down the heirs and have them sign an affidavit and basically release it on behalf of the
I had two heirs do that in the last
Perfect.
year. Yep.
Yeah.
It was the two sons said, nope, so and so's a family friend. He paid off dad. They weren't quite sure when, but it was in the aughts and we got it squared away.
Yeah.
We had a similar one. It was kind of fun. Well, not fun. It was unique. We had a private entity that was the lender. Everything had been paid off. Entity went out of business. They were no longer active. The members of the entity, we tracked them down. Okay, good. There's these two guys. They're both dead. So we had to then go even further to the heirs of the members of the inactive entity to get our release and go forward. It was fun.
All right, everybody, if you're just joining us, this is the Creative Finance Collective, and we're just a bunch of lawyers talking about creative financing. That's what you've come in on. And if you have any questions, feel free to to ask us along the way. My name is Andy Fowler, and with us today we've got Sean St. Clair, Nick McGrew in California, Drew Jenkins in Alabama and Georgia, Alan Seschker in Texas, Scott Horne in Texas, and Jeff Watson out of Ohio. So we got a lot of brain power here to be able to answer any complex creative financing questions that you may have. The more complex, the better. Why not? Sean, we had talked about a transactional question just the other day, and I wanted to pose it or give you an opportunity to pose it. And we were talking about calculating the amount of a second position seller financing. Why don't you explain that and pose that to the group?
Yeah, one of the things that I've come up against just in kind of a drafting perspective, I'm just curious how you guys have addressed it, is what language are you using in your forms to deal with the situation where you have, say, the property's worth, going to sell for purchase price of 500, first position loan of 400, and then the seller's going to carry the 100, right? But we all know that the payoff of the loan isn't going to be an even $400,000, right? It's going to be, 385 or 420 or 425 or some, with dollars and cents rounded out. And I kind of struggled with, okay, well, crafting some language in there, like how the second position, it's not going to be 100,000. We say it's going to be, but what kind of language are you guys using to basically make it so that the numbers can be adjusted at closing to reflect the actual payoff at closing, and then what the actual seller financing amount is going to be, if that makes sense?
So you're talking about a sub 2 plus a seller carryback?
Yeah.
So that's the bane of my existence for right now. They're called, hybrid.
Right.
I don't know which guru came up with them or which attorney came up with them, but all you've done is you've taken a mortgage wrap and you've broken it into two pieces, an assumption and a seller carryback. And so there's two different ways I've been handling them, but gosh, I hate them. I'm just like, let's go back to a mortgage wrap. And I understand why they're there, especially if you want to sell that second note or something like that. But I use my sub 2 language where the amount doesn't matter. Payoff is whatever the payoff is. And then if I can, usually it's, $30,000 seller finance carryback, 0% interest, $1,000 a month for 30 months. I just embed that secondary language into my sub 2 promissory note. But there's no good way to do it. So if we could undo that hybrid system or method, it'd be cool. It'd be really good.
Yeah, but what do you do you said the 30,000, but we all know it's not going to be 30,000, right? Because the payoff is never going to be exactly what we think it's going to be, when we break out the numbers to determine the purchase price. So what do you do to allow the parties to basically adjust that second position seller carry to reflect the actual, get you to the purchase price, right? Does that make sense? So you have 500, say we think the first position loan that's subject to is going to be 400,000, and then the seller is going to carry whatever remaining equity there is. But we don't know the exact amount of that, seller second position loan at the time the contract's entered into, because you have to actually get the payoff from the first position lender to figure that out. Do you see what I'm saying?
Yeah, no, I see exactly. So I'll defer to others, because by the time the folks get to me, they're saying, hey, I'm going to take over your mortgage and give you an extra 30,000. So this problem doesn't rise to the level of me. So I'll listen to the others.
Well, I'm going to agree with Alan that, when we're drafting these kind of questions, number one, I want those current mortgage statement, in my possession to make that decision, in order to draft up the contract and or to disclose appropriately at that time. I actually have a set amount so that we're pretty doggone close to start off. Now, if you can't, you can base language upon particular whatever the existing mortgage is, where either the underlying mortgage goes or the contract is A or B. And I've got that provision in my transactions where which one's going to amount or contract amount so that you're able to quickly calculate what that second lien should be, unless hard and fast set dollar amount. But I prefer to get out and off by a buck or two a day. So what? It's not going to hurt the deal, I don't think.
Right. Yeah, a buck or two doesn't, I mean, that's here or there, but you know, normally, and that's the problem, right? You know, you're smart because you're getting the mortgage payoff or the mortgage statement up front and, you know, making those calculations. Obviously, if there's a foreclosure pending or scenario like that, those numbers are going to be skewed and a lot different. So I don't know. Anybody else have any thoughts on like crafting language to basically say, look, the second position loan, I guess, is just adjusted to reflect the difference between the purchase price and the payoff of the second position loan?
So I just
some language.
Yeah, I just shot some language in the private
Yeah.
chat that I pulled, and I have a feeling that it's language very similar to what Scott uses, because I think I saw this in documents that probably passed through Scott's office a few years ago. And, you know, when I see something good, I will then put it into my own, if you know what I mean. So that's some language that I've seen in the past regarding adjusting the price, and that language is obviously skewed in the favor of the investor buyer, where we'll adjust the price based upon what the real payoff is. So
a variation of that could be used to solve Sean's problem.
yeah. So I went digging for it, and that's the language I've been using. It's worked fairly well, because I've got a business partner in Dayton, Ohio, that's probably doing about 4 sub-2s a month, and he's consistently calling me going, okay, how do I use your stuff to do this and so on. So, you know, this, I know what I'm sending him is working, and it's working because he's closing at multiple title companies. So what I'm using is tested and works in Ohio. I'll leave it at that. Yeah.
Yeah. And that's the thing, you know, in Arizona, we have,
too, you know, go ahead, Sean.
you know, in Arizona with the title companies, they do all the back end work. They'll even draft the notes, you know, unlike the closing attorneys that, you know, basically take it from step one all the way through. You know, you have the attorney, then those forms and documents are handed off to title, and that's kind of the thing that I know I've been talking to a few title folks on is, you know, the contracts that are being submitted. And I've added some language to my contract to deal with this, but the contracts that are being submitted just break down the purchase price amounts and how they work. But then they go to draft the second position deed of trust, and they're like, well, wait a minute, the, you know, payoff was 15 grand higher than what we anticipated. And so now the purchase price is going to be 15 grand higher. I should reduce the second, but I don't have language to that effect. You know, it's all the logistics that, you know, go into the transaction with all the parties involved.
Guys, we got a question from one of our viewers on YouTube, and I know a lot of you probably have something to say about this, so let me go ahead and pose the question. You guys have at it. JR says, what about insurance? I see a lot of this coming up, and the right way to get insurance with a creative agreement. When I first read that, I read and assumed that was talking about property insurance. I'm not totally sure if they're talking about property insurance or title insurance. It could theoretically be that, so maybe address it from both of those.
They're talking about the hazard insurance in all likelihood.
That's what I think. Yeah.
Yeah. And we've bounced around different ways over the years. You know, used to say buyer and seller both get the insurance. It's just a cost of doing business. Used to say add seller as an additional insured, but I'll break down and parrot what the insurance agent that we use does. Seller terminates their insurance, buyer gets new insurance. Seller is going to be an additional interest, not additional insured. And then obviously underlying mortgage as their mortgagee clause. Lender also has their mortgagee clause and protection. And that's the way that they tell me they do it. But I'm just parroting what trusted agents do in Texas.
We recently had an issue with a
And I'll
group I work with. This was down in the Virgin Islands. And it was very creative how it got put together. But one main sticking point that delayed the closing had to do with how on earth is this thing going to get insured? And in their case, they just kept trying to find different insurance agents, right, or carriers, until they found one that said, this is how we're going to insure it, that, made the lender comfortable and that, the borrower was willing to play ball with. In that case, I was on the lending side. But it certainly is an issue that comes up. And sometimes it's just a matter of keep asking around until you get someone who's at least willing to play ball.
Scott, were you going to add something?
Yeah, I was just on Alan's camp. I will say I believe that the seller should be listed as assured or additional because they're actually the borrower in a subject to type transaction. On their mortgage companies will throw if they're not listed as that co-insured out there. Now, one of the things that I still see to this day, though, in the industry is I see double insurance of property where these investors will seller's insurance in place and then get a whole new. So there's actually two insurance policies going on at the same time. If you want to see a cat fight, if there's a risk of loss out there, I don't know who's going to wind up winning that in the day, but we strongly suggest you the two partners.
What are you seeing, Jeff, in Ohio when it comes to insurance?
So I'm counseling my clients, and we're insuring stuff very similar to what Alan described, but I make sure that I get my ATIMA and my IOSA language in there. ATIMA, as their interest may appear, particularly with the seller, who I leave on there as a named insured. And then I always want to get the language for the lenders, and or successors and assigns, that abbreviation in there as well, because I know that note's going to get traded or moved around. So but we generally get rid of the first policy after, I'm going to say it again, I'm going to say it one more time, after we get the new investors policy in place, coverage bound, so that we've got good casualty insurance in place. Then we'll get rid of the seller's policy and go from there.
Agree.
All right. I'm sorry. Who'd I interrupt? Nobody. We're good. All right. Hey, so guys, that's an hour. And I don't want to take up any of your time. You guys all been generous to be a part of this and shared a lot of good information. Can't wait to share more with you guys and answer more viewers' questions in the coming weeks. Folks, if you're just watching or just finding us, this is the Creative Finance Collective, an opportunity for professionals who are getting their hands dirty in the space of creative finance to talk through the issues, to answer your questions from a multiplicity of different perspectives and different jurisdictions, because as you know, the law changes from state to state. So if you enjoyed it, make sure to be with us, guys. Thanks so much for coming on. Hope you can come on some weeks. Hope you can come on every week. We're always looking forward to sharing good information and looking forward to doing it with you guys again. You guys have a good week.
Thanks, guys.
Thanks, Andy.
Thank you.
All right.
Thank you much.
All right.
Appreciate
We'll see you
it.
guys next time.